Good morning to all. Today my topic enrichment provision in articles. The 2013 Act introduces the enrichment provision in respect of the article of association of a company. An enriched clauses or enrichment clause of a basic law or constitution is a provision which makes certain amendments either more difficult or impossible inadmissible. It may require a form of supermajority submitted to the people or the consent of another party. Next, section 14, alteration of articles. A company may alter its articles subject to the provisions of the Companies Act and its memorandum. A special resolutions must be passed on in the general meeting of the shareholders, altering the provisions in the article, including alterations having the effect of conversion of a private company into a public company or a public company into a private company. Approval of the tribunal is also required for converting a public company into a private company. A copy of the resolution altering the articles and a copy of the order of the tribunal shall be filled with the requested together with the printed copy of the altered articles within a period of 15 days in the prescribed manner, who shall request the same. Section 14 provided that, subject to the provisions of this Act and the conditions contained in the memorandum, if any a company may be special resolutions after its article, including alteration having the effect of conversion of a private company into a public company or a public company into a private company. Provided that where a company being a private company alters its article in such a manner that they no longer include the restrictions and the limitations which are required to be included in the article of a private company under this Act, the company shall, as from the date of such alteration, to be a private company. Provided further that any alteration having the effect of conversion of a public company into a private company shall not be valid unless it is approved by an order of the central government on an application made in such form and manner as may be prescribed. Provided also that any application pending before the tribunal as on the date of commencement of the Amendment Act 2019 shall be disposed of by the tribunal in accordance with the provisions applicable to it before such commencement. Every alteration of the articles under this section and a copy of the order of the approving the alteration as per subsection shall be filled with the registrar together with a printed copy of the altered articles within a period of 15 days in such manner as may be prescribed, who shall request the same. Any alteration of the article registered under subsection shall, subject to the provisions of this Act, be valid as if it were originally in the articles. Next, section 50, alteration of memorandum or articles to be noted in every copy. Every alteration made in the memorandum or article of a company shall be noted in every copy of the memorandum or articles as the case may be. If a company make any default in complying with the provisions of subsection, the company and every officer who is default it shall be liable to a penalty of 1000 rupees for every copy of the memorandum or articles without suit alterations. Next, Restrictions on the alteration of articles. The alteration of article must be done considering the following matters. First one, the alteration must be consistent with the provision in the Memorandum and the Companies Act. Second, the alteration shall not result in any in liability of existing shareholders unless the company obtains their consent in writing. Third, the alteration shall not be consistent with the order of central government, court, or opposite to public policy. Fourth, the alteration shall not affect the interest of any third party or result in any breach of trust. Fifth one, the alteration shall not be fraudulent. Sixth one, the alteration of articles when a public company is converted into a private company must be approved by the tribunal. Last, company cannot avoid contractual liability by altering its article. And next, distinction between memorandum and articles. The following are the differences between memorandum and articles of associations. First one, the memorandum is considered the charter of the company. It defines the powers and objects of the company. The articles are the by laws containing rules of internal management of the company. Second, the memorandum defines the relationship between the company and outsiders. The articles define the relation between the company and its members. Third, the memorandum is the supreme documents. It is subordinate to the Company Act only. The articles are subordinate both to the memorandum and to the Companies Act. Next, model memorandum is given in table A, B, C, D and E of Schedule 1. Model articles are given in table G, H, I and G. Fifth, an act ultra virus, the memorandum cannot be ratified by the whole body of the shareholders, but in act ultra virus the article, but intra virus the memorandum can be ratified by the shareholders. Next, memorandum contains lesser clause than the article of association. Next, article of association contains provision for enrichment. Next, the alteration memorandum is difficult, especially the object clause. The approval of central government or tribunal is required for altering certain clauses, but the alteration of article is relatively easy. It requires only passing a special resolution in the meeting of the shareholders. And last one, the memorandum cannot be altered very easily. Hope it is clear. Thank you.